Hello, everyone who has joined us so far. Sorry, we're starting a couple minutes late. Good old teams, couple technical difficulties, but we're rolling along now. Um, I'm sure some more people are going to trickle in as we move along here. So, without further ado, let's kick it off here. As many of you know me already, I'm Dylan Hallahan. I'm the Director of Long-Term Care, Disability, and Life Insurance here at Emmanuel Insurance. We have also JT Crosby, who many of you probably know again from our prior presentations. He's our Director of Sales at Emmanuel Insurance, head honcho here. And then we have our special guest speaker, Dan Abraham, who some of you may also know. Dan Abraham is the man. He's a business attorney and partner, business law attorney and partner over at Keam and Abraham LLC, attorneys at law. They do some amazing work. He practices in both litigation and also corporate transactions. He's been in the business for a long time. I think about 25 years, right, Dan?
Yep.
Yeah, so long time. He knows his stuff, and he's going to be speaking, and he'll get into the details. But he's going to be speaking on operating agreements, more of what he's seen, what he's experienced with operating agreements, some of the things that you probably want to avoid and look for. So I'm really excited. This will be a really good one, especially for our business owners out there. And without further ado, I'll turn it over to Dan and let him talk a little further and jump into the topic for us. If people do have questions, if people have questions, there's a chat, there's a Q&A section. Throw those questions up. JT and I will be monitoring that. Anything we can answer, we will. Otherwise, we'll turn it over to Dan at the end. So appreciate everyone. And now take it away, Dan.
Thanks, Dylan. Thanks everyone for attending today's presentation. I'm going to give a quick lawyerly disclaimer at the beginning that we're talking generally about operating agreements. Nothing we talk about today should be considered legal advice for anyone in their personal situation. If you've got something you want to talk about, we can talk about it offline, or you should consult with your own legal professionals about it. I'm going to put a PowerPoint up. I've only got 4 substantive slides, and I'm going to try to get through them in about 12 to 15 minutes so that we can leave time for Q&A afterwards. If anyone has questions, I'm going to ask that you just put them in the chat box. Actually, I don't see a chat. Oh, there it is. Okay, yeah, put them in the chat box, and if I don't catch them at the end, Dylan maybe can help me suss those out, and we can address them all. So let me go ahead and share the PowerPoint. Bear with me just a sec. Can everyone hear me okay, by the way? Okay. Okay, so can everyone see the PowerPoint?
It's loading right now, Dan. Looks like. There it is.
Okay. Should say at the top, operating agreements, do's and don'ts.
Yep, we got it.
Okay, great. So let's start out with, before I even get into the next, the first substantive slide, what is an operating agreement? It's a document that sets forth the rights and responsibilities of the parties, that is, the owners of the company, with respect to corporate governance of the entity. It's essentially this. Now, for operating agreements, we're talking about LLCs, limited liability companies. That's the governing document for a limited liability company. If we were talking about corporations, we'd be talking about a shareholder agreement. They cover essentially the same topics, just one's for a corporation, one's for a limited liability company. So if you have a corporation and not an LLC, this still pertains to you. We're just going to call it something a little bit different. When we get into the key provisions, they're all going to be the same. And one more caveat: if you're a one-person, a one-member LLC, you don't have any partners, or you're a single shareholder of a corporation, in all likelihood, this does not apply to you. The operating agreement or the shareholder agreement applies typically when you have partners, because what you're really doing in the document is setting out the different rights and responsibilities that each of you have. If you're a single member LLC with no partners, you pretty much do whatever you want. And with limited exception, you don't really need an operating agreement. So we're really talking about where you have partners. Okay, so let's get into the slides. Okay, who are Joe and Bill? Joe and Bill are guys that come to my office. This is the generic Joe and Bill that come to my office, and they come in, they say either we don't have an operating agreement, or they say we've known each other for 30 years. We've been in business for half of those years, and we've never had an operating agreement. We've never had any problems. We don't need an operating agreement. And my caveat there is do we? The biggest mistake I see is having no operating agreement or a bare bones operating agreement that says something like, we're 50-50 partners, we share profits, we share losses equally. Joe is the manager, Bill is the vice president. And that's sort of the extent of it. This is fine. And it keeps working until it doesn't work, until life happens, until something happens to change one of their personal situations. So let's talk about some key provisions that can address some of those things. So we've got taxes and allocation of profits and losses. This is a key consideration. How will the company be taxed? As an LLC, you can choose to be taxed however you want. The law is pretty lenient in this way. You can be taxed as a partnership, in which case the company will issue K-1s. You can choose to be taxed as an S corp. You can also choose to be taxed as a C corp. Most small businesses don't do that, but you can make a tax election, and then a decision has to be made about how net profits and net losses are going to be allocated. A decision has to be made as to whether a distribution is going to be made from the LLC to cover taxes. And then there's the question of who's responsible for preparing and filing the tax returns. Usually the operating agreement would nominate one of the partners to become the tax matters partner. That's how it's referred to in the operating agreement. So it's very clear which partner is going to be responsible for taking care of taxes. It doesn't mean they're not going to talk to the other partners about it. They're going to. It's just that one person is going to be designated to take the lead. Definitely, you're going to want to consult with your tax and accounting professionals with respect to taxes in the operating agreement. And typically, when I'm drafting an operating agreement, I work hand in hand with the CPA, because as I'm drafting, it's not, it's up to you guys as the business owners, how you want to be taxed and how you want to allocate profits and losses. And so it usually involves a conversation with the owners of the business together with the CPA to make sure that we can get it right and document it properly in the operating agreement. Next issue is voting rights. This covers management of the company and voting rights generally. It's usually tied to ownership interest, which is to say if you own the company 50-50 with your partner, there's two of you, you each own half. Typically, the voting follows the ownership interest. So you each get a 50% vote. If there's three partners, it's the same. Each person gets a 1/3 vote. And so two people can outweigh and outvote the third person. But just keep in mind, it doesn't always have to go that way. Just because you're 50-50 owners, you could have one partner who's a manager who gets management responsibility to run the day-to-day affairs of the company. That would give really more power to the manager, even though they're 50-50 owners. You could also have 50-50 ownership, but choose, for business reasons, for one person to have a 60% vote and one person have a 40% vote. And there's all kinds of different reasons why this might happen. It might be that you each own 50% of the equity, but maybe one of you made a greater capital contribution to form the company, and so you have more at risk, and so you get a greater voting right. Okay, this is all negotiated between the partners. Is the company managed by the managers, or is it managed by the owners, by the members themselves? How are the managers appointed? Do the members get to nominate them? Is there some other board or committee established to nominate them? And if you don't have management authority, there should be a mechanism in the operating agreement for how you can voice your opinion. What if the manager is doing something that the other owners of the company aren't thrilled about? Do you have any rights? Do you get to call the meeting to vote on a particular matter? These are really important things, particularly if there's multiple owners and only one manager. The other owners want to have the ability to have some kind of control over the management of the company, even indirectly. Another question is, are managers compensated? Do they set their own compensation, or do the members, the other partners, get to approve their compensation? Next topic is additional capital contributions. How do we know if the company needs more money? There should be some metric in the operating agreement to address this. If there is a need for more money, how is the amount of capital for the contribution determined? Is it by the manager unilaterally? Do the members get to vote on it? And then something that comes up all the time is, what happens if there's a capital call? The company needs more money, but you got, I don't know, say there's 3 owners, and say you got two partners who contribute, they make the capital contribution. You got a third partner who doesn't contribute, either because he doesn't feel that there's a real need for the capital call, maybe doesn't financially have the ability to make the capital contribution. What do we do? Does the non-contributing member automatically get diluted so that they don't own as much equity in the company? Or can the contributing members, the 2 partners who are willing to make the contribution, can they chip in for the guy who's not contributing and treat it as a loan to that non-contributing partner that's subject to, a promissory note and repayment with interest? This can be addressed and should be addressed in the operating agreement. The next big topic is transfers and buy-sell agreements. There's a lot of negotiation around this area. And this is really thinking about exit strategy. What happens upon the death or disability or bankruptcy or divorce or retirement of a partner? What happens if a partner wants to sell his or her interest? Is there a right of first refusal or a right of first offer? There's often, and we always are recommending, and the parties often get some kind of life insurance or key person insurance, but this can raise other kinds of questions. I mean, I've got one now that I'm negotiating where there are 2 partners. A company it's a young company, but they're doing some really good numbers. One partner is in her mid-30s and very healthy. The other partner is in his mid-60s and he's got some health issues. So they got life insurance, but her annual premium is a little under $4,000 a year, and his annual premium is $14,000 a year. She's paying for his insurance, he's paying for hers. Doesn't seem fair, right? That she's got to pay all this extra cash for his expensive insurance. Well, there's a way we can solve for that in the operating agreement. We can have the company pay for it and cause distributions to be made to each partner to even out what they paid in life insurance, so that the net effect is that you combine the 2 insurance total premiums of $14,000 and $4,000 to $18,000, and each party ends up paying the equivalent of $9,000. So we can kind of spread that out. But just one of many examples of what can come up with insurance. Dylan can certainly talk about that and probably answer questions too. Next key provision is dispute resolution procedures, decisions. I always recommend decision gets made up front. If you end up with a dispute with your partner, um, do you go to alternative dispute resolution, something like mediation or arbitration, or do you just leave it open to go into court? And this can apply to issues of corporate governance. It can apply to business decisions. Resolution of deadlocks is a big deal, especially if you've got an even number of owners. If you've got two owners and they can't agree on something, you've got a deadlock. You should have some kind of mechanism in the operating agreement to resolve it, whether it's mediation or what we call a Russian roulette provision that forces one partner to sell their interest to the other. And then the last big topic is dissolution and termination. What causes the company to end its existence? Typically, dissolution occurs when the partners all consent to end the LLC, or you go out of business, or there's a judicial decree ordering dissolution. But it doesn't end there, because what happens to the company's assets after it's dissolved? If it's a successful company and the reason it's dissolving is because there's a deadlock, most likely the company's going to have significant assets. And then the question is, who gets to keep those assets if you have multiple partners and the company's dissolving? So we have to think through at the beginning what happens to those assets on dissolution, and it's part of what gets built into the operating agreement. I see we got some questions popping up in the chat box. I'm actually almost done. Let's get into our next slide. I'll be quick on this one. How should we tailor our operating agreement to your business needs and goals? My suggestion here is to think about things practically. The operating agreement should not be some esoteric document that nobody understands because it's loaded up with legalese. The reality is that it's not so it's not such a big lift for a lawyer to write up an operating agreement if he's being thoughtful about it. The hard part is thinking through all those key provisions and the exit strategies. So my suggestion is think about things practically, think about what can go wrong, and work backwards from there, and make a list and share that list with your attorney to help craft an appropriate operating agreement. I've got an LLC questionnaire that it's got very specific bullet points. It's just a couple of pages that lists out things to think about and questions to ask to elicit answers that will allow me or your attorney, whoever drafts the operating agreement, to put it together for you. It's rudimentary, but it's a good starting place. And if anybody wants a copy, you can email me and I'll send it to you. Another great resource for tailoring your operating agreement is talking with your own personal CPA and the company's CPA, because they're going to be in tune to the financial needs, which really drives a lot of what you're addressing in the operating agreement. And then my last slide is what happens if you don't have an operating agreement? Well, we've already talked about it. Nothing really happens unless life gets in the way. You have a death, a disability, a divorce, a bankruptcy, retirement, or a deadlock. Any of those things happens, and then you've got an issue, and you don't have an operating agreement. You're kind of throwing caution to the wind on how those things are going to get resolved. So, and that then goes back just to our key provisions. So, I don't want to end on a low note and talk about all the things that can go wrong. The reality is that when people go into business, they do so optimistically. Nobody wants to say to their new business partner, "Hey, let's talk about everything that can go wrong in our relationship." It's not a great way to start things out. But if I can put words in your mouth, I would suggest that you think about it and talk about it with your partner as, "Hey, let's talk about and plan an exit strategy. What happens if I get disabled? What are you going to do with the business?" Most people can get their heads around that and get on board with it. And you can get into conversations about the importance of disability insurance and life insurance, and then that can lead to a broader conversation about exit strategy and some of the things that we talked about. So that's all I've got. I'm going to stop there. Let me stop sharing and
Yeah, we've got quite a few questions, Dan. If you want to, I can read them if you'd like, and then you can answer and work through them.
okay, yeah, that's great. As long as if everyone's okay on time.
Sure, yeah. So let's, JT, I saw you had that first one there. How often should operating agreements be reviewed?
I think I recommend an annual review internally, not necessarily by council, but an internal review by the owners of the company. Take that thing out of the drawer, dust it off. Let's just kind of, I don't know, pour a glass of wine and go through it together, see if anything's changed. So an annual review, I think, is a good idea. But absolutely, any significant change in the business operations or ownership structure, absolutely, you have to pull that thing out and review it. You bring in a new partner, that changes everything. You don't have to remember to do it then. The new partner is going to say, "Hey, let me see your operating agreement. I want in."
Yeah, I think that segues way well to Roshni's question here too. It's many small businesses start with simple template agreements, right? When they grow, they add partners, investors, or key employees. What are some common challenges you see pop up with these situations as businesses grow?
To be candid, the biggest issue is people forget about that operating agreement, and it becomes a back burner item, so that you're focused on, and rightly so, you're so focused on your business. I mean, that's operating agreement's not making you any money. Your business is making you money. So the thought that you have to take time away from your business to address the operating agreement, nobody, it's not sexy, it's not interesting, nobody wants to do it. So the biggest hurdle really is getting everyone on board to take the legal Zoom document that you downloaded and to say, hey, this thing, we got, it doesn't cover all of our bases, or we don't know if it covers all of our bases. Let's get attorney review on this thing and make sure that everyone feels comfortable with it. And I'll tell you something else. And this is not a plug for me. It doesn't matter to me if you call me to do it or you have your own attorney. Somebody should review it though. And it should be reviewed from the company's standpoint, but also for each individual owner's standpoint. That's another big pitfall that I see, is that you have the company's attorney draft the operating agreement, but the ownership interest isn't equal among everyone. If three people own 1/3 each, fine. There's some equality already built into that structure. But if you've got one person that owns 40%, and then two other people that each own 30%, now you've got a scenario where every people's interests differ, and so they might have different needs and goals in the operating agreement that would want to be addressed. Doesn't mean that a minority partner can push around the majority partners, but it should be a negotiation. And the point I'm making is that your personal interests may differ. It definitely differ if you're a minority interest.
And I think the biggest challenge that, it's funny, but the biggest challenge too with growth, and we see it in our side, within the insurance and the buy sell and funding that as well, is just the fact that people don't review it. They set it, they forget it. They grow, life changes, things change within the business, valuation changes, and none of these things are ever looked at again. And that's where you really fall into some deep trouble.
Absolutely.
Um, Moving on, what is the typical cost? This is from JT again. What is the typical cost for a business owner to get an operating agreement in place? I guess that's on an average, some sort of range.
Yeah, it's a fair question. It's a very difficult one to answer, so you'll forgive me if I'm a little slippery about it. Um, so I have had situations. So you may find lawyers that do it on a flat fee basis, or I don't know, depending on the size of the business, a few thousand, 3,000 or 5,000. Most lawyers I know, myself included, are on an hourly billable rate to do this. And the reason is because you don't know how much negotiation there's going to be back and forth, how complicated it's going to be, how big the company is, and how complex their needs are. And all of that is going to drive the cost. I can tell you that I've had very simple operating agreements where there's just two partners and everything is rosy and nobody disagrees about anything. I draft something, the accountant signs off on it, the parties are happy, and it's 2,000, 2,500 bucks. Not a big lift. I will tell you that I've negotiated larger, more complicated ones that have cost $20,000. Um, and that's for a company that's doing annual revenues in the tens of millions, with a lot of partners, and it's complicated. So, but if you want to hear about the average, I'd say probably for a small business, probably in the 5 to 7 range.
Yeah, we come across business owners all the time that don't have an operating agreement already in place, or it just hasn't been touched for a long time. And so like that's a question that gets posed to me about like, oh, well, what do you think that's going to cost? And I said, well, it all depends on the attorney that you use and what their rate is. But I'm sure, just like you said, it could be a flat rate or an hourly rate based on how in depth it needs to be. So.
Yeah, I think
Yeah,
that's
for
right.
sure. And Dan too, also before people do start logging off if they have to go, if you could put in your information, Brian asked for this as well. I'd also love to have it. That questionnaire, that LLC questionnaire that you have,
Yeah,
if you could put in your email, your contact info so people can reach out just in the chat, that would be awesome. And then I also had a question as well, because we deal a lot with family-owned businesses, which I find are always trickier, especially when it comes to them having that operating agreement and more specifically that buy-sell within it, that buy-sell portion. And I think more of it's just an awkward conversation to be had, and they don't feel like having it. I'm just curious to how you typically, I guess, battle that, with family-owned businesses and, really saying like, listen, guys, you should have this, and here are the reasons why.
yeah, it's a great point, Dylan. I've done operating agreements between mother and son. I've done them between brothers and siblings. Um, it's I, I don't have a great I don't have a great piece of advice on that, but I can tell you is we've we've done everything from kind of a holistic approach where we have group, kind of like what we're doing right now. Everybody gets on a Zoom or a Teams call, and we just have open conversation about everyone's needs and interests and concerns. Sometimes it's just a matter of letting people vent about, hey, this is stupid. Why are we doing this? We're family. And then letting a neutral third party from the outside share with them the war stories of, let me tell you where I've seen things go wrong between mother and son, and they don't talk anymore because of this. And I've also had situations where we've gotten a mediator involved. In fact, I'm working on one right now where there is a mediator involved. It's two brothers that own a real estate investment property down the shore. It's a rental property, multi-million-dollar property that throws off revenue. One partner didn't want to do an operating agreement at all, didn't feel like he needed it. Turns out it was the other brother that was doing all the work for the property. The one that didn't want to do an operating agreement was just sitting back collecting checks. So, rather than me get in the middle of it, we got a mediator involved, and they did some sessions with a mediator. And sometimes this stuff ends up being a little bit like therapy, talking through the family issues. So to me, most important on that is communication. If we can get people talking, then we're typically working towards something.
Yeah, absolutely. And Dan, this is another really great question by Tom, actually, and I can definitely chime in here, but I'd be curious to your thoughts as well. So Tom asks, what happens during the course of underwriting, which again, this is probably a little more for me, but during underwriting a buy sell when one or more of the partners is uninsurable. Curious if you ever run into that.
I have not run into the, oh, no, that's not true. I did one last year where that happened, where there's two partners. One of them is my age, in her early 50s, and the other partner is in her early 80s. And it's not that she's uninsurable, but the cost of her insurance, it was just silly. I mean, it made no sense
Hmm.
for them to do it. I'd have to go back and look at exactly what we did, but if I remember correctly, um, we proceeded with a, uh, a staged purchase. In the event that the older partner died, we created all the purchase documents already, the promissory note, the purchase documents, everything that allowed the younger partner, if she survived, to buy out the older partner's interest over a 7-year period of time to give her the flexibility to come up with the cash. Because that's
Right.
the real issue, is you end up in a cash crunch. If the business is worth 4 million, you got one partner's got to come up with 2 million overnight without insurance. It's a problem, but the solution on that one was we just staged it out over a 7-year period of time with no prepayment penalty. So the idea was that she could go into the market, the surviving partner could go into the marketplace, get a business loan, pay it off in full, and then pay the bank back the loan, or could choose to pay off the estate of the deceased partner over up to a 7-year period of time with quarterly payments. And we had a valuation formula that was done by a certified business valuator. So that's how we handled that. But Dylan, I'd actually be curious if you had other.
That was going to be almost my exact answer, actually, because we've seen that before, where we've had uninsurable business partners for one reason or another. And yeah, it's just, you think about what a buy sell is in the instance of a life insurance, right? A death. And life insurance, really what it's meant for is when that partner passes away, funds are immediately available to buy out their shares from the other partner, right? So that's the whole purpose of it, is to buy out those shares of your business partner. So if we don't qualify through the life insurance part of it, well, unfortunately, that's where we're kind of like, hey, okay, well, that's as far as I go on my part, right? And now we have to look for other ways for you to be able to come up with those funds. Like Dan just mentioned, a lot of times it is that just agreed upon ahead of time, paying it over a certain period. Maybe there are different assets tied to it that you can promise towards that, however it is. But unfortunately, at that point, it's like, well, life insurance isn't the answer. So it's just a matter of working with your attorney to figure out what that next step is. So yeah, I mean, you hit the nail right on the head, Dan. That was going to be exactly, and I've seen it. It's unfortunate, but it does happen. So I just wanted to, as long as there are no other questions, I just wanted to thank everyone for hanging in too. And I know we're 5 minutes past, but these are some really great questions. Dan, thank you so much for your time. It was really some really great information. I learned a couple things, which is always great. You are the man, and if anyone needs anything at all or has any further questions, reach out to Dan. He's a great resource. Reach out to myself and JT. Obviously, you guys know what we handle, but we're really the insurance specialists in this. So we're always happy to work with Dan and be able to refer him over some things as well. JT, I don't know if you had any final words.
No, I appreciate it. I always love these, and the fact that we get these little pieces and these nuggets to take with us to share with the people that we're touching. It's awesome. I'm looking forward to the next webinar, and we'll get this posted on our YouTube channel as well, so it's there for people who couldn't attend. Dan, I'm going to email you now so we can get a copy of that LLC questionnaire. I think that'd be great if
Yeah.
or unless you're able to put it in the chat, that'd be good too.
Yeah, due to technical difficulties, I'm not at my computer right now. But when I get back to my computer, I'll email it to Dylan, and you guys can post it. Fine.
Great. Thank you so much. Thanks everybody.
Thanks for attending, everyone.
Thank you.
Thank you.
This was great.
Thanks, Roshni. Take care.
Thanks, guys. Great job.